So good afternoon, everyone. And first of all, if you haven't got your microphone on mute, if you can just put it on mute now, so we've got no background noise, that would be great. Good afternoon, everyone. Welcome to this joint Foyle 9 St John Street Chambers event on fatal accidents. Just a quick plug before we start, just to make sure you follow Foyle on LinkedIn. And if you haven't registered on the Foyle website, please do so you can be on our mailing list for any future events. So today we have Julie Ann Luck, who is a barrister from 9 St John Street.
Hello.
Hi. Still more people coming in the event as well. So I'm trying to do two things here. So yes, we have Julie today from 9 St John Street, who's a barrister. She's going to guide you through the handling fatal accidents. I'll tell you a little bit about Julie before we start. So Julie has 30 years of experience working in the field of personal injury claims. First 12 of these spent as a solicitor and partner with BLM, and the past 18 years as a barrister. Over the years, Julie has dealt with many fatal accident claims. Often they involved fatalities occurring in the course of RTAs, but also many deaths arising from clinical negligence. She's represented both claimants and defendant insurers on such claims, which has given Julie a helpful perspective and understanding of the issues and difficulties that both sides must navigate. So, before I hand over to Julie, if you have any questions as we go along, if you could put your question in the chat facility, and we'll try to pick up as many questions as we can at the end, depending on time as well. So without any further ado, I shall hand you over to Julie Ann Luck. Julie.
Thank you, Ian. So welcome to my guide to handling fatal accident claims, and thank you for joining me on this dreary December afternoon. Well, it's certainly dreary here in Manchester. I don't know, maybe the sun is shining wherever you are. This talk will cover the relevant law when it comes to handling fatal accident claims. It's going to look at the quirks and provide useful practical tips. I will consider who can claim, what can be claimed, how claims are assessed, and some recurring issues in financial and services dependency claims. Now, the talk is intended to be as comprehensive as 1 hour will allow. It will start off with some fairly basic information, but as the hour progresses, it will become more complex. And if I may apologise in advance, this talk is not intended to cause death by PowerPoint slides. However, they are quite detailed and I've prepared them as such so that they can be distributed after the talk, so that they can provide a useful aid memoir in the future when you handle such claims. So, and as Ian says, we'll attempt to answer as many questions as I can at the end, but there may not be much time, so you are free to email me if you wish with any queries. I'd be happy to answer those. So I'm going to start with the governing law. The right to claim following a death caused by a tort is based in statute, and there's two acts you need to be aware of. The first one is the Law Reform Miscellaneous Provisions Act 1934. That enables a claim by the estate of the deceased to recover the losses of the deceased. The second act is the Fatal Accidents Act 1976. That's been described by Lord Sumption as the sole legal basis in English law for a claim for bereavement or loss of dependency. But then you also need to be aware of the case law interpreting these acts. So a few observations. In all cases involving fatal claims, you must still prove causation between the original tort and the death. The issue of contributory negligence can also be argued. Limitation can sometimes be a little complex. In simple terms, it's 3 years from the date of death or date of knowledge, whichever is later. However, until recently, there was some uncertainty about the legal position if the primary limitation for the personal injury claim had already passed by the time the claimant dies. There is a new case on this issue called Shaw and Maguire re Preliminary Issues from 2023, in which Master Cook has held that Section 33 of the Limitation Act can be used to override the limitation period, even if it has expired prior to the deceased's death. Now, the really important thing for you to note from today's talk is that the method of assessing quantum in fatal accident cases is completely different to personal injury claims. And that method is underpinned by statutory provisions interpreted by case law. It's not the common law of tort. So there are some quirks when it comes to dealing with these cases. And as a consequence of those quirks or idiosyncrasies, there can be sometimes quite arbitrary, even unfair results. And whilst the judiciary may want to do justice between the parties, they are constrained by the statutory wording. And the courts may, they obviously have to apply the statute to reflect the will of Parliament. And the judges will sometimes use twists and turns to try and make it as fair as possible. But the reality is, in some cases, claimants may actually receive a windfall, effectively receiving double recovery of certain elements of their claim, whilst in other cases, it can actually be the converse is true, and it's quite unfair, and certain claimants will suffer irrecoverable losses. So when you deal with these claims, you need to adapt your mindset as they are dealt with prescriptively, applying the acts, and they are often counterintuitive. Lord Sumption again noted how the Fatal Accident Act is a departure from the ordinary principles of assessment in English law, which can fairly be described as anomalous. And repeating the words of Lord Diplock, he said that the Fatal Accident Act calls for an artificial and conjectural exercise whose purpose is no longer to put dependents, particularly widows, in the same economic position as they would have been in had their late husband lived. So as I say, the assessment of the damages is very different to that in personal injury claims, where it's all about putting the claimant back in the position they would have been in but for the negligence. And this talk is going to give some examples of the unfairness that can occur. So let's get down to basics. Who can bring the claim? This is firstly, who can bring the claim under the 1934 Act? It's only the personal representatives, that is, the executors or the administrators of the deceased estate. Under the Fatal Accidents Act, again, it's usually the personal representatives that bring the claim, but there's an important distinction here. If they don't bring a claim within 6 months of the death, then the dependents of the deceased can actually bring the fatal accident claim. So some practical tips here. At the outset, make sure you request the grant of representation, because the grant of representation enables you to identify the personal representative that's entitled to deal with the estate and the claim. There are two types of grant of representation. There's firstly the grant of probate. Now that only applies where there is a will and therefore where there are named executors. The second type is letters of administration. They apply where there is no will because the person has died intestate, and they go on to name a particular person or persons who can administer the estate. So on the right side of the screen there is an example of letters of administration. So let's take a closer look at the claims under the Law Reform Miscellaneous Provisions Act 1934. This act provides that the action the deceased would have made, sorry, just pausing there, I can hear somebody typing, so if you're not on mute already, please could you place yourself on mute? Thank you. So under the 1934 Act, this essentially provides that the action the deceased would have been able to bring on their own account had they not died survives the death for the benefit of their estate. Essentially, the estate of the deceased inherits the benefit of the claim. And so the personal representatives step into the deceased's shoes to bring the claim on behalf of the estate. Now, looking at the available claims under the 1934 Act, there are some overlaps with personal injury claims. Firstly, there's a right to claim PSLA, and that follows a similar process to that in ordinary PI claims. But a very relevant factor in these cases is the time which elapses between the injuries being suffered by the deceased and their eventual death. So in the case of Hicks against Chief Constable of South Yorkshire Police, which I believe was a case arising out of the Hillsborough tragedy. Oh, I think it's the Hillsborough tragedy. Anyway, I shall move on. The House of Lords in that case held that no damages would be recoverable where the deceased suffered for a matter of seconds before unconsciousness and ultimately death occurring. Practical tip here is check out the Judicial College Guidelines, Chapter 1, because that section covers injuries resulting in death. And it looks at specified periods between injury and death and whether there was awareness of the death, and gives some appropriate brackets. Now, also under the 1934 Act, there is a right to claim special damages, for example, damage belonging. So in an accident, perhaps involving a motorcyclist, the cost of the motorcycle will be recoverable. Expenses to death can be claimed, such as hospital expenses if they spent some time in hospital, and past care and past loss of earnings incurred prior to death. Now, while so far there is a similarity to valuing the claim for a living claimant, there are some important distinctions. One is that a living claimant can recover what's called their lost years, and that is a proportion of their future earnings and pension they would have earned for the rest of their life expectancy, less expenses. So it's usually calculated about, as a rough guide, at 50% of what would have been their future earnings and pension for the rest of their life, but for the anticipated premature death. So that's the situation for a living claimant. Where a claimant dies, then under Section 1(2) of the 1934 Act, unfortunately for them, there is a specific exclusion of any claim for post-death loss of income. Now, in many cases, that won't matter too much, because once the claim is transferred into a fatal claim, the dependent spouse can make the claim for financial dependency under the Fatal Accidents Act instead. But in other cases, the exclusion can amount to a windfall for the defendant. So, for example, I have been acting for a 35-year-old claimant with a 12-month life expectancy, and her lost years claim was for obviously loss of earnings and loss of pension, and that actually spanned a 50-year period. She had a late diagnosed skin cancer. Very sadly, she died unexpectedly last month before we managed to settle the claim. So that means her lost years claim has died with her as a consequence of the 1934 Act. She has no spouse, no partner, but is the single parent of a teenage daughter. And so that means that her 50-year lost years claim is going to be replaced by a financial dependency claim by her teenage daughter, which is probably only going to span 5 or maybe at most 8 years. So that is the case, really, an example of unfairness in these claims, and the defendant essentially getting a windfall from the unexpected slightly early death. And again, it shows the prescriptive nature of fatal accident claims. So some observations then about Fatal Accident Act claims. They provide a right of action for wrongful causing of death. Again, contributory negligence can be discounts for contributory negligence as in an ordinary PI claim. There are some procedural requirements that you need to be aware of. First one is under Section 2(3). only one action may be brought in respect of the death. So that means you expect only one set of legal proceedings claiming on behalf of the estate and on behalf of all the dependents. Now, under Section 2.4, the claimant must deliver up the dependents' names, etc., to either the defendant or the defendant's solicitors. And also, they are to identify the nature of the claims for which damages are sought. So a practical tip here, at the early stage, very earliest stage, make sure you request all the dependents' names. And this is really important because no doubt you might want to be settling the claim pre-action. And if you do, then you must be aware of a fairly recent case called Core and Brocklebank, which was heard by Mr. Justice Turner. In that case, the claimant had intimated his own claim and mentioned gave no details of any dependents. The defendant made a pre-action Part 36 offer, which was said to relate to the whole of the claim. That was accepted by the claimant. However, the claimant then went on to issue court proceedings claiming on his own behalf and on behalf of other dependents. Now, the defendant then tried to get the claim struck out on the basis that there's a pre-issue Part 36 that had been accepted. Mr. Justice Turner accepted that the Part 36 settlement meant that the claimant's own claim was to be struck out, but he held that the claims of the other dependents were still viable. And that was because, he said, Section 2.3, the one action only rule, does not apply to Part 36 offers made pre-issue. And the other dependents, the claims by the other dependents, had not been mentioned in the correspondence. So if you want to make an effective pre-action Part 36 offer, you need to make sure you have details of all the dependents who wish to claim before making the offer. There are some other procedural requirements there on the screen about what the particulars of claim must state. The actual dependents are not themselves named as dependents. The only claimant is actually the executor or administrator, but the particulars of claim must plead the names and full date of birth, etc., of the dependents. If it's a child dependent involved or someone without mental capacity, then you need to get approval of any subsequent settlement under CPR 21.10. Okay, so moving to potential heads of damage under the Fatal Accidents Act. There's the 4 heads of damage there, which you can see on the screen there. I'm going to deal with each in turn now. So let's start with the bereavement award. This is a fixed sum, and it's the same, so it means it's the same regardless of the level of grief. It's the date of death that determines the relevant bereavement award, not the date of the claim. So if the death was after 1st May 2020, the claim is £15,120. If it was at a date prior to that, it was £12,980. That was back to 2013. Now, few people would consider the value of the lost life is fairly reflected in this statutory sum, but as I say, it's a fixed sum, so it's not something there's any discretion over. In terms of eligibility, as you would expect, spouses, civil partners, cohabitees can claim, but they have to have been cohabitees for at least 2 years. Parents of minor children can claim. So as a minor child dies, the parent can recover. However, there are some oddities here. For example, the mother of an illegitimate child can claim bereavement damages if the child dies, but not the father. And one that I really struggle with is the fact that where a child loses their parent, they have no right to the bereavement award. So in the case I mentioned earlier involving the 35-year-old mother, I actually attended her funeral on Tuesday this week. And as I watched her grief-stricken 13-year-old daughter try to bravely speak about her mum, I kept thinking about bereavement awards. Ridiculous, I know, but this talk was coming up, and I could not comprehend the injustice that in her case there is no entitlement to a bereavement award because she has no spouse, wasn't cohabiting for 2 years, and her daughter has no right to claim. So as I say, the criteria is strict. There's no discretion. However, it may be open to challenge under the European Convention on Human Rights. So who knows? Maybe that's a case to consider that. So moving on. Funeral expenses, they are recoverable under the Fatal Accidents Act. They are recoverable under both this Act and the 1934 Act. However, double recovery is not permitted. The Section 3 Dependency Award provides dependents with the right to claim compensation for damages as are proportion to the injury resulting from the death. The injury is the pecuniary and non-pecuniary benefit which the dependent has lost as a consequence of the death. It's basically the loss of practical and financial support. So the claim falls into two categories. There's a right to claim services dependency and financial dependency. What you need to be aware of is something called the reasonable expectation test. And that's because the loss is measured by the financial and practical support the deceased would reasonably have expected from the deceased had they not died. So the fact that a benefit has not been enjoyed prior to the deceased's death is not actually a bar to recovery, so long as there was a reasonable expectation of it being enjoyed in the future. So, for example, say the pregnant daughter of a deceased, she might be able to claim that she had a reasonable expectation that the deceased would have given childcare services to the baby when it's born, but for the grandmother's death. However, it would be stretching it to try and claim for, say, siblings of the unborn child, because that might be considered a mere possibility or speculation. Now, in terms of the eligibility to claim dependency, the list is on the slide there. It is a wider list than those eligible for claiming bereavement award. Again, note the Act is prescriptive, it's archaic, it's out of touch with modern days of living. An example of this is the stepchild of a deceased step parent can only claim if their deceased step parent was actually married to or in a civil partnership with their biological parent. So where you've got a sort of an example of modern ways of living, you might want to check the exact wording of the Act to see if there is eligibility. As I say, it can also be unfair. So for example, the deceased had a much loved friend who was disabled, and that disabled friend was very dependent upon the deceased for giving them care. They have no right to claim under the Act. However, say there's an ex-spouse who was completely despised by the deceased, that ex-spouse would be entitled to claim, subject to proving they had a financial or services dependency upon them. So if you are uncertain whether the claimant is eligible, please check Section 1 of the Act. Take a sip. Now let's look at calculating the services dependency and what can be claimed. There's some obvious examples: loss of childcare, cooking, cleaning, laundry, gardening, window cleaning, DIY, etc. Now there's no definitions here, and claimants could be creative. For example, I am pretty reliant on my husband's IT skills, as Ian has just seen before we all joined on today. So if I were to lose my husband, then I think I would be claiming for dependency on his IT skills. So say no strict definitions, there can be some creativity here. It's a four-step approach. The first step is to calculate the multiplicand. then the past losses, then calculate the multipliers and calculate the future losses. Let's take a look at each of those steps in more detail. Calculating the multiplicand. This is about assessing the annual cost of replacing the services the deceased would have provided to the dependent but for their death. Now, the valuation is not determined by what the dependent reasonably needs. As mentioned earlier, the test is what the dependent could reasonably have expected from them. It may change over different periods of time because as the deceased children get older, for example, what they would reasonably have expected from their parent will reduce, and so the multiplicand will reduce. So you'll have to have lots of multiplicands for different periods of time. In terms of assessing what it is, it's a question of fact. It's based on evidence from the dependents, but there is a growing trend to bring in expert care evidence. The case of Nauer and MOJ from 2014 is a case that claimants may attempt to rely upon. In that case, the wife died at age 46. It had been a very traditional marriage. The court described the division of labour as something out of the 1950s. The husband claimed the commercial cost of a housekeeper working 20 hours per week. And the defendant, though, argued that 5 years on from the wife's death, there was still no cleaner or housekeeper employed by the husband. He'd been managing himself. So they argued that there was no loss, there should be no award. Now, the court said that submission was misconceived and made a rather strange analogy. It said, if a claimant's brand new Rolls Royce is written off through the defendant's negligence, then damages must include its replacement value, even if the claimant decides he will change to a cheaper car or in future take public transport. So they said the same principle applies to claims for loss of services under the Fatal Accidents Act. So rather bizarrely, the wife was compared to a written off motor vehicle, but I think the analogy makes the point. It doesn't matter how the care is replaced. It's all about assessing what's been lost. And so the court allowed 20 hours per week for household tasks, and it actually based them on the cost of employing an agency, which back in 2014 was £16 an hour. So that made a multiplicand of £16,000 per annum. So as I say, at the bottom of the screen there, the dependent is entitled to the commercial cost of replacing the service, and it's irrelevant that they've so far managed without commercial help. So what, however, is the situation if a replacement carer has lost earnings in order to look after the children? Now, lost earnings are not recoverable per se under the Act. But there are some cases that indicate where the new carer of the children has reasonably given up work, then their loss of earnings can be used as a proxy or a yardstick to measure the value of the care dependency claim. And this occurred in two cases that appear on the screen there. In Creswell and Eton, the aunt gave up work as a traffic warden to care for the children. Her loss of earnings were used as the proxy to measure the claim for replacement care. But in my view, those cases don't seem to be consistent with more recent cases. For example, Welsh Ambulance Services against Williams is a claim that concerned financial dependency. I'm going to consider it later, but essentially that case said that dependency is fixed by the intentions of the deceased at the time of the death, and nothing that a dependent, or for that matter anyone else, does after the death can increase or decrease the dependency. So that to me seems very difficult to reconcile with this idea that where somebody post-death gives up their job, that their lost earnings can be used as a yardstick to measure the value of the replacement care. But I think the take-home point here is that where the strict application of the Act is going to result in an unfair decision, some judges will do what they can to fudge a fairer solution. So yeah, I call this some judicial fudge. That's a picture there of my daughter just demonstrating what judicial fudge looks like. This does make running cases to trial unpredictable, but it does provide fertile ground for negotiation. Another point to note is that very careful pleading is required. An example of this is Ruperthing against West Hertfordshire Hospitals from 2016. In this case, the husband died. He'd been the primary carer of the couple's young children. Their mother gave up work as a UK doctor, and she returned to her homeland of Sri Lanka with her babies. She claimed that but for her death, she would have stayed in the UK and qualified as a consultant, and she claimed £1.4 million for lost earnings. In addition to that, she claimed dependency on her husband's income and childcare services. Now, the defendants here were very canny because by the time of the trial, they settled her claim for dependency on income and services for £335,000. The only issue at trial was her claim for loss of earnings of, say, of 1.4 million. Now, what the court said was her decision to give up work was wholly reasonable. And the court also accepted that her loss of earnings were potentially recoverable if they had been claimed as a proxy to measure the value of the care that had been provided by the husband. However, loss of earnings are not recoverable per se. There was a last-ditch attempt by Mrs. Ruperthing to convert her claim for lost earnings into, to dress it up essentially as a proxy for the services claim. But that attempt failed because she had already settled her claim for dependency on services. And the court said if she were now to attempt to try and recover her loss of earnings through that route, that would essentially amount to double recovery. So there'd been a fatal mistake in her case in terms of the way the claim had been pleaded and presented, and that meant her loss of earnings were completely irrecoverable. Whereas she might have got a much more significant dependency claim if she tried to dress it up in terms of her lost earnings. And I think that case really demonstrates how the optics matter. The way a claim is presented can make or break its success in terms of value. Now, as I said, the next step is to calculate the past losses. The past losses are calculated to the assumed date of the trial. Why the date of trial? Well, that's because there's a Supreme Court decision from 2016 called, well, it's now we're in Ministry of Justice again. It was the Supreme, the previous case went to the Supreme Court, and that confirmed that the multiplier for future losses is to be calculated from the date of trial. So past losses go up to date of trial. There's a simple equation to apply, plus interest. However, note, you want as a defendant to be applying the Ogden discount. And this is to discount the past losses to reflect the fact that the deceased may have died by the time of the trial in any event. And you do this then by applying table E from the Ogden tables. So example here, say the deceased was aged 70 at the time of death, and it took 4 years for the case to come to trial. So we've got 4 here, and then you find where the column and the row meet, and it's 0.96. So you apply that to the claim for past losses to get a small reduction in the overall value. Now, I thought it'd be helpful to consider a case study to bring some of the issues to life. This is a real life case that I dealt with earlier this year on behalf of the defendant insurers. The mother very sadly suffered a fatal accident while she was cycling to work. Liability was admitted. She had children aged 7, 12 and 14. She worked school hours only as a carer in a care home. Her husband, he worked evenings until 3 a.m. as a butcher preparing the meats in a supermarket. It was a traditional marriage. She'd been the prime carer of the children. Now, in this case, the claimant solicitors really knew how to maximise the claim. There was a fully pleaded schedule of loss at the time I became involved, and in fact, there was expert evidence already on the case. And here we can see the claim. The Law Reform Miscellaneous Provisions Act claim was fairly small, and the reason for that was it was small was because that she had died in theatre within 24 hours of the accident. So the claim for PSLA it was put at £5,000, but in fact the defendant's offer was about £1,500 on that. The remainder of that claim was made up of funeral expenses, the cost of her broken bicycle, and a few other special damages. The fatal accidents claim, however, exceeded £1 million. And as you can see, the large element was the services dependency at £835,000. Now, in calculating the multiplicand that led to that £800,000 plus claim, the care expert took a staged approach. He looked at the care the children that the mother would have provided to her children right through all their primary school years, through college, sixth form college years, university years, reducing until, of course, the time they'd flown the nest, and also the care she would have given to her husband. But in respect to specifically the children, because this the husband, whilst the wife had been alive, had worked until 3 a.m., he calculated it upon care of 38 hours per week, i.e. outside school hours, until 10 in the evening. And he also included 5 sleep-in shifts at £45 per shift, plus additional cost expenses. And that came out with an annual multiplicand of £50,000. That's £50,000 per annum. Now, the first question the defendants wanted to know was, why is there a claim for evening care and sleep-in shifts when the husband had switched his working pattern to daytime hours? Now, as I said at the outset, the problem is with these cases, it is a completely different assessment to personal injury claims. It's not about what the injured claimant reasonably need, because now the father had given up his job, his evening job, and replaced it for daytime hours. They didn't reasonably need care in the evening. But the difficulty we as defendants had was this case of Welsh Ambulance, which I mentioned before, which says that the dependency is fixed by the intentions of the deceased at the time of death, and nothing the dependent or anyone else does after the death can increase or decrease the dependency. So the claimants in that case were arguing the fact that the husband had given up his evening shifts had no relevance to the value of the claim. It's not about reasonable needs. It's about what the mother would have provided and what the reasonable expectation of would have been of the children and husband. Now, the defendant's expert, I was already, when I took on the case, the defendant's expert he'd been instructed, he'd been to see the family, and his draft report was provided. And what was quite astounding was he agreed with the calculations of the claimant's expert, save he said that his research indicated that it was no longer common for nannies to charge a standard sleep-in rate. So he allowed an hourly rate until 7 a.m, coming out with an annual multiplicand of 62,000. And now let's contrast that with the claimants of 50,000. We then had a conference with him before, obviously, his report was finalised. Firstly, we challenged the 7 a.m. finish. Evidently, the husband was home at 3 a.m, so he'd really misread the evidence. Then we challenged our expert about whether the mother could really be deemed to be providing services when she was sleeping. He thought she was because there's a background supervisory element of childcare, but we still asked him to provide a second approach to his figures. So his report essentially had two sets of figures, the second approach being the hands-on care only, i.e., what mum being woken in the night because there's a nightmare or child feels sick. And that approach brought the annual multiplicand down to £22,000. And so what we did was we obviously we pleaded the counter schedule on that basis, and the case went on to a JSM. So let me just see if I'd finished everything I had to say on that particular slide. Yeah, I did want to just tell you about the JSM. We did have a successful JSM. It settled for 372,000, less than the pleaded figure. It was a good result given the expert evidence of the defendant. But I think a real learning point from that case is the fact that it's probably advisable to get a desktop report from your expert, so you know what they're going to say, because of course with a care report the claimant knows you've got it because they visit the claimant's home. But once the deceased has, in the case of a fatal accident case, it's all about what the provision expectation of the deceased at the time of death. So I think a desktop report would be the best way forward. Okay, so returning to the methods. Check where I'm up to on my slides here. Yeah, okay, so I'm returning to the methods here for ascertaining the value of the services dependency. You want to, the next step is to ascertain the multiplier for the future loss. This relates to the duration of the dependency. You need to consider the life expectancy of the deceased, and you need to consider the life expectancy of the dependents. So a practical tip is to seek the medical records, because if, for example, the dependent had a terminal illness, then the dependency would be very much reduced. You then follow the method in the notes to the Ogden tables, paragraphs 139 to 141, and you adjust in accordance with the new discount rate, which has just changed from minus 2.5% to plus 0.5%. On the screen there, you can see an example of using the multipliers in the case study I've given. Now, it's incredibly dry and turgid for me to take you through that example, but it's there to follow if you wish. I'm not going to do it now. Right, so that's all about the services dependency. Let's now move on to the financial dependency. This is the financial loss suffered by the bereaved family as a consequence of the death. As with services dependency, there's a four-step approach: calculate the multiplier, the past losses, sorry, multiplicand, past losses, multiplier, future losses. In terms of calculating the multiplicand in a financial dependency claim, there are two potential methods of calculation. You've got the rule of thumb method, which is known as the Harris and Empress Motors method. Now that assumes all income is pooled into a joint purse, and it assumes the couple spent a fixed percentage of the joint purse on themselves. A third of the income would be spent on themselves if childless, 25% if they had children. And the financial dependency is then calculated by ascertaining the value of the joint purse and then deducting the amount the couple would have spent on themselves and the income of the surviving spouse. And the balance of that gives you the value of the annual financial dependency claim. I'm going to give you some examples to bring that to life in a moment. But the second method of calculation, though, is what's called an accurate calculation. Now, that's based on detailed scrutiny of actual circumstances. This is a very expensive method of dealing with it because you need to gather all the bank statements, and you really need to get into the nitty-gritty, and will probably involve experts. But it might be argued for, that method will be argued for if the deceased was in receipt of significant income and failed to spend anything like a third of the income on himself. Okay, so as I say, I wanted to bring the Harrison Empress method to life for you. This is an example where the deceased worked. In this case, I'm suggesting the net earnings of the deceased was 60,000. The surviving spouse didn't work, so 0. So therefore the joint earnings are 60,000. They had no dependent children, so the assumption is that a third of the income was spent on themselves, 40,000. You then deduct the surviving spouse's net earnings, 0, because the spouse didn't work, and the annual dependency is then 40,000. I jump that example. This is both working, no dependent children. And I'm going to move now to both deceased and surviving spouse working, and they had dependent children. So again, deceased earning 60,000. In this case, spouse earns 25,000, joint earnings 85,000. You deduct the 25% because they have dependent children. And then you deduct the surviving spouse's net earnings, 25,000. So that means the annual dependency loss that can be claimed is 38,750. In my case study, both the parents worked, as I said before. They had dependent children. The claimant in that case had instructed a financial accountant expert, and the approach taken was to break down the multiplicand for different periods. So, for example, they were looking at pre-retirement earnings, including inflation of earnings. You might also have cases where it's expected there'll be promotions, and then also you might have there was a change in the dependency rate from 75% to 66.67% when the youngest child became an adult. And then you also have to look at the period post-retirement when pension income is involved. So as you can imagine, can be quite complex process. On behalf of the defendant, we didn't have a financial expert, but we were still able to make some inroads because evidentially we noted issues that suggested the deceased earnings were less than detailed in the report. We noticed that the financial expert had ignored the husband's overtime and bonuses, so his earnings were actually more than in the report. And all of the approach of the expert had resulted in a skewing of the figures to the husband's advantage. So these were things we were able to argue in the counter schedule of loss and at JSM. Now, quirks to be aware of when calculating the multiplicand. First thing is section 4 of the Act, which is the disregard of benefits provision. Now, this provides that in assessing damages, benefits which have accrued or may accrue to any person from his estate or otherwise as a result of his death shall be disregarded. The consequences of this can be quite complicated. It means, firstly, there's no need for the claimant to give credit for insurance payments that result as a consequence of the death. That's a fairly straightforward one. More complex is where there are pensions paid in consequence of the death, and there's some cases there that deal with those issues. For example, the case of Piddock confirms that Section 4 does catch occupational widows' pensions. But I say that the law there is complicated. Another example is where dependents inherit a business that prospers under their watch, so there's no real loss. So as I've mentioned this case of Welsh Ambulance a few times, I'll just tell you a little bit more about that case at this point. The family, they had inherited the deceased's property development business. And what the defendant argued was that each family member had received more profit each year since the death than they had before the death. So in truth, they said there's no loss consequent on the deceased's death and no viable dependency claim. But the claimant argued that the loss was to be valued by reference to the cost of replacing the services the deceased husband had provided to the business as both a manager and property developer. As I've already mentioned, the court said dependency is fixed at the moment of death. Nothing anyone does after the death can either increase or decrease it. The court said the dependency, the value of the dependency was therefore the same whether the dependents had tried to run the business and failed, or tried to run it and succeeded, as they had in this particular case. The court accepted that the correct way to value this claim in this particular case was by reference to the contribution of the deceased as the manager of the business, because that is what had been lost to the family. And so the financial dependency was valued by reference to the net cost of employing a replacement manager for the business. So given this business had gone from strength to strength since the deceased had died, and there was no loss of profit suffered, in that case, you can understand the defendants felt that it was a windfall for the dependents, and essentially sort of double recovery had occurred. And as I've said before, though, it has been acknowledged by the judiciary that the results of applying the Fatal Accidents Act can be described as anomalous. There's also issues in applying Section 4 where the beneficiaries inherit an income-producing capital asset. So, for example, if it's a rental property that's inherited, then according to a case called Wood and Bentle Simplex, these are not caught by Section 4. If you inherit the goose, the court said, you cannot claim to be deprived of the eggs. Some other quirks: if the dependent cannot work due to grief, they're so distressed by the loss of their husband, they can't return to work, tough. It's still assessed as if they were working, because it's assessed at the time, the loss is assessed at the time of the death. So in that case, the dependent is going to suffer irrecoverable losses. And you know, the best advice in the case of a surviving widow would be to find a new wealthy husband. Why, you may ask? That's because under Section 3(4), which is quoted on screen there, the remarriage or remarriage prospects of a widow are not to be taken into account when assessing her damages. Now, bizarrely, there's no similar provision for men. The academic Attaya has described this clause as one of the most irrational pieces of law reform ever passed by Parliament. It's certainly archaic, but I think practical tips arising: manage your client's expectations, educate your client that they need to forget about fairness. It's about the strict application of the Act. And there's going to be some winners here, there's going to be some losers, and that's just the way it is. The next stages for financial dependency is, as with the services dependency, you calculate the past losses, you calculate the multiplier, and as before, it's about considering the life expectancy of both the deceased and the dependent and comparing those. It's about applying the Ogden tables. When you calculate their future losses, the multiplier is applied to the post-trial, is applied to the multiplicand to arrive at the overall lump sum. But note, there are actually two discounts that are to be applied under the Ogden tables. The first one is the discounting factor for contingencies other than mortality, which is under Section B of the Ogden tables, just as quite similar process to future loss of earnings. with a living claimant. But as well as that, you apply the Table F discount to reflect the risk of death before trial. Note that there are other arguable financial claims that a claimant might try and seek, for example, annual Christmas gifts or wedding gifts. Loss of intangible benefits are also recoverable under the Fatal Accidents Act. This is a head of damage you might sometimes see referred to as the Reagan and Williamson Award. It's essentially a lump sum that's supposed to reflect the irreplaceable quality of the services provided by the spouse or parent. It's generally £3,000 to £5,000, but there is some controversy here over whether it's recoverable or not. I won't go through the cases mentioned because I'm just very conscious of the time. So I'm coming to the end now, and I'm just going to give you some conclusions and practical tips. Firstly, know the quirks here. There's the quirks over eligibility, and there's also the point about optics matter. I mean, that case of Rupa Singh that I mentioned, mother couldn't recover her standalone loss of earnings claim, but if she had dressed up her services dependency claim as using her lost earnings as a proxy, she might have secured a higher settlement. So as a defendant, you need to, representing the defendant, you need to know the law, spot the undervalued claims and try and get those ones settled quickly. Claims can be undervalued simply because of a lack of understanding of the law. So some claimant solicitors may value the claim for lost services using gratuitous rates, whilst others who are more savvy are aware that they can claim commercial rates. So if you see a lost services claim using gratuitous rates, try and get that element settled, because it can result in vastly different valuations for the same claim. Take a view, choose your battles. If it looks undervalued, settle it quickly, because you want to look at the bigger picture. Don't bother seeking receipts for funeral expenses and nitty gritty. If, you know, on the face of it, it looks okay, looks reasonable, get it settled. And try and avoid the claimant obtaining care expert evidence, because that blows up the value of the claim. Try and maintain that you'll dispute permission. You might not get very far with that argument, but you can certainly have a go. If you need an expert, start with a desktop report so the claimant doesn't know you have it. This could avoid you being stuck with an unfavourable expert, as occurred in my case study. Obtain the grant of representation early on so you know you're dealing with the right people. Obtain medical records, including those of the spouse, as early as possible, because that will enable you to look for any life expectancy issues and ensure you're calculating the correct period of dependency. Consider Part 36 offers, but remember, if settling pre-action, ensure the claimant has identified all the dependents, or you risk your Part 36 offer failing to resolve the matter entirely. Remember the case of Core and Brocklebank, which I mentioned early on in the talk. So following on from that, ask the claimant solicitor to fulfill the Section 2(4) obligations, letting you know who all the dependents are early on. And then finally, consider early conference with counsel. Preparation of a robust, without prejudice, counter schedule of loss might be helpful, and JSN. So that is it. Thank you very much. I am sorry, we're actually okay, 14:01, perfect timing. Save unless there's lots and lots of questions.
Thanks,
so,
Julie.
Ian,
Well,
thank you.
Yes, we've got a couple of questions, Julie. So
Yes.
both from Paul. So the first one, just rewinding a little bit. Can a grandchild of the deceased recover for, say, birthday presents?
I would say yes, a grandchild could recover birthday presents if they can show that that those birthday presents were provided annually. That's just going to be a matter of witness statements, perhaps some photographs supporting it. And but obviously the courts do adopt a reasonable approach to it, and they may only provide birthday presents until a particular period of, until the child is perhaps age 21. I think sometimes when I've seen cases where, say, a spouse is claiming for particularly lavish Christmas gifts, one thing to be aware of then is that obviously where there's lavish gifts, they will reduce, they have an impact on the financial dependency. So as lavish gifts go up, arguably the financial dependency might come down a little. Okay, do you want to try the next question?
Okay, so the next one, again from Paul. So if, we've got another one come through now. So if surviving spouse did work pre-death but doesn't post-death due to grief, etc., can death set off his or her pre-death earnings from the dependency multiplicand?
Can you put, so spouse stops working following the death, and the question was, could you repeat the question there, Ian? Can
a deaf DF set off his or her
dependent?
Yeah, that's it.
Well, in terms of taking it stage by stage, the claim will, the claim under the 1934 Act is purely for the deceased estate, so they're not relevant there. And then in terms of the Fatal Accident Act, the claim is going to be for the dependency, financial dependency. I don't see how you'd be setting off the pre-death earnings, because the dependency claim is all about what's post-death. Do you see? So the pre-death earnings of the spouse don't come into the calculations in either under either act. It's the under 1976 Fatal Accidents Act. It's about the post-death situation and the post-death dependency, and it will be assumed, as I said in the talk, that the spouse would have continued working. Sadly, very, very unfairly, but that is the way it's worked, and as I say, it's prescriptive. But no, I would say that the pre-death earnings of the spouse are not set off. Okay,
good. So a few more questions from Ian Cummings. So we see care loss of earnings claims up to 25 years old being pleaded refinancial calculations. What is your experience through the court over these ages from 2 to 3? 75%.
Sorry, repeat that. So you see care and loss of earnings. Of course, is there any way I can see the question?
Yeah, if you click onto the chat.
Yeah.
And then, yeah, so you got Ian's question, third one down.
We see care and loss of earnings up to 25 years old being pleaded refinancial calculations. I'm not too sure what need some explain the question. Up to 25 years old being pleaded. I'm assuming this means that you might see people claiming care. The 25-year-old, say their mother dies, they're claiming care. In my experience, once the child hits 18, it goes down really considerably. The dependency on care from the parent goes down really considerably to, 3-4 hours a week. I mean, it depends on the circumstances. If it's anticipated at 18, the child of the deceased is going to go to university, it might be pretty small, a couple of hours a month or something like that. And after 21, it's negligible. So certainly, I don't think beyond 25 there's much scope for recovering either financial dependency or services dependency. Okay, next question.
Okay. So we've got from Charlotte, if a claim is settled for a global amount, but the court needs to approve a child element of the settlement, how would they go about apportioning the child's damages allowance?
This is an interesting question, but something as a defendant you don't need to worry yourself too much about. So saying that, I mean, you want to ensure it's approved, but ultimately it's a case for the claimant team to work out the apportionment. You can help them, I suppose, by trying to indicate what the apportionment is. So say it settles at a JSM, you can discuss what the apportionment is intended to be. But ultimately, it is a decision, something that the claimant team need to sort out. Okay.
Okay, good. And we've got one from Rita. Are the funeral expenses probate expenses on claiming if the death is related to the accident?
So the funeral expenses are recoverable, but not the expenses such as the wake, the sandwiches and the drinks, etc. Not the and the cost of a memorial, that's not recoverable. Probate expenses, the case called Mawson against Spousal confirms that probate expenses are not recoverable, but sometimes there is an attempt to claim those, and sometimes defendants might just let that one go under the carpet, because one of the important things is to really try and establish a good negotiating rapport with your opponent. And sometimes there's no point upsetting the family over a small claim for probate expenses when you've got the bigger picture of the dependency to deal with. As I meant, within the practical tips, choose your battles. And I think that's one battle that some defendants might think it's not worth having. You want to save the battle for the real one, which is the dependency.
Okay. Oh, sorry, Rita's just added something there. Sorry, is this applicable even if the death was not related to the personal injury?
No, you've got to have causation to make the recovery. If the death is not related to the injury, if the negligence hasn't made a material contribution to the death, then there's no causation, and therefore there's no entitlement to any of this. The estate can claim for can continue the claim for the original personal injury accident, but the fatal aspect of it doesn't come into play. There's no that's just not recoverable. Okay.
Yep, that's all the questions. So
good.
Thank you, Julie, for that presentation. It's been really informative.
Thank you.
I hope
You're very welcome.
Hope it's helped everybody who's on the call. So the presentation has been recorded. We will put the presentation on the Foyle website probably in the next couple of weeks. We also did one through 9 St John about insurance fraud, which is going to go onto our website as well in the next couple of weeks. Right. So keep a lookout for those.
Yes, as I mentioned, if anybody wants these slides, we can also arrange for those to be distributed to you. I meant to put my clerk's email address, but contact me or telephone Chambers, and we'll get the slides to you if you want to have them.
Brilliant, thanks, Julie. And I think about hearing about death for the last hour, I'm going to wish you a cheery goodbye.
Yes, happy Christmas, everybody.
And have a good rest of the day. Thank you very much, everyone. Thank you.
Thank you. Bye-bye. Bye-bye.
Bye.